that owe a duty to their patrons and third parties. The fundamental reasoning behind this category is the powerful incentive that commercial hosts have in over-serving alcohol to their patrons. The appellants, in paragraph 21 of their factum, state that this case does not fall within existing categories of duty of care because it is not known what the level of intoxication of Mr. Briggs was at the time of the incident. The appellants thus assert that not knowing the toxicity level of Mr. Briggs is a novel situation that requires the application of the ANS test. The appellant's argument in this respect, with all due respect, is flawed. The level of intoxication does not change the relationship of proximity between commercial hosts, their patrons, and third parties. As stated by this court, the question of whether a duty of care exists is a question of relationship between parties, not a question of conduct. The question of what conduct is required to satisfy that duty is a question of an appropriate level of standard of care. The other argument posited by the appellants in paragraph 23 and 17 of their factum is that this case is novel because it does not involve a motorist on a highway such as in Stewart. However, we submit that whether a person is driving, biking, on a motorcycle, or walking, the principle for finding a duty of care between commercial hosts and third parties remains the same.
Can we go back to your point that you say the level of intoxication doesn't matter? Because it seems to me that makes it much wider. It means a commercial host can be liable for serving alcohol, period, for any risk that happens over there. And I thought that the prima facie duty of the recognized category was grounded in the fact that it's intoxication that can create a risk and that you should guard against over-serving people. So isn't that not intrinsically part of the understanding of that category?
Yes, Your Honor, that is absolutely an intrinsic part of the commercial host owing a duty to their patrons not to overserve alcohol, and that is what we meant by the level of toxicity, because as the appellants asserted, that question of whether Mr. Briggs, or to what level Mr. Briggs was intoxicated, is a matter that would be decided under the standard of care analysis, and not whether a duty exists or not in the present case.
I misunderstood what you said then.
Thank you. May I proceed?
Yes.
Thank you.
You'd be happy if we said no, perhaps, but I'll say that.
As in the present case, because the commercial host stands to profit from selling alcohol to the public, whether someone is driving on a highway or walking on Granville Mall, as was Mr. Donaldson, the same duty of care applies. We further submit that the rubric of a third party in describing the duty of care owed by a commercial host is in fact not needed in this case. It is an established category that commercial hosts owe a duty of care to their patrons, which in this case includes both the parties involved. Mr. Donaldson and Mr. Briggs were both patrons of the Oktoberfest hosted by the appellants, so proximity is well established. Furthermore, Mr. Briggs used a souvenir glass mug supplied by the appellant as a weapon to injure Mr. Donaldson. So reasonable foreseeability is also established in this case. Your Honors, I will now turn the podium over to my co-counsel, who will continue with the second and third issues raised in this case. Thank you.
I'm going to move on to the second and third issue, which is concerned with the ANS analysis. And let me preface this by saying that, as we pointed out, that it's unnecessary to apply the ANS analysis because, as my co-counsel has demonstrated, this is a well-recognized, well-established duty. And as we also pointed out, Mr. Donaldson and Mr. Briggs were patrons, they were guests of the appellants. The court found in Stewart's versus Petty, every person who enters a restaurant or a bar is in an invitee relationship with the establishment, and this therefore constitutes a special relationship. Now, that's why we say there is proximity. Now, let us assume for a moment, going by the logic of the appellants, that this is a novel situation, and let us also assume that, again, as the appellants assert, that Mr. Donaldson and Mr. Briggs are third-party Ann's analysis, we will still reach the same outcome, and a duty of care will arise for 3 reasons. 1, there was foreseeable harm. 2, there was a foreseeable plaintiff. And 3, there are no definitive policy considerations that will negate this duty. This court should take judicial notice that alcohol consumption reduces one's reasoning capacity. It is common knowledge that diminished reasoning skills associated with alcohol can have dangerous consequences. And there are no shortage of examples that point to this. We've seen this in the precedent cases. As was also established in Stewart versus Petty, a duty is owed to third parties who might reasonably be expected to come into contact with an intoxicated patron and to whom that intoxicated patron may pose some risk. In order for the guests of the appellants to go home, to go to their places of residence, it is inevitable that they would interact with members of the community. The appellants ought to have reasonably known this. The appellants also...
Just let me interrupt you. Is the risk the fact that a mug was given, or the fact that the patron walked home? So does every bar owe a duty to, if someone walks home, is that an inherently dangerous act, or is it the mug?
It depends. In this case, walking happened to be quite dangerous, as we have seen. However, in terms of where that danger comes up, I think in the questions of remoteness, I think what you're pointing to is the question of how broad does this liability extend, and to that I respond that just because there's a duty of care owed does not mean that the bar would be liable because a person exited that venue. It depends on whether reasonable precautions were taken. It depends on whether a standard of care was met. It depends on whether there was sufficient causation. That's my response.
So you put all the work, both you and your co-counsel, in the standard of care, it seems to me.
But that's part of it. It's not only the standard of care. It's also causation. It's also whether damages resulted exactly as a result. So it's not only standard of care. If it's found that it's not reasonable, that it's too far, remoteness, I think, is a great place where we can investigate this. If the resulting harm was too remote from the action, then the appellants, then there wouldn't be liability.
All right, so redefine for me at this point how you would define the outer limits of this already recognized category. How do we define it? A commercial hose is one part, extends to what?
It extends to all those who may be reasonably expected to encounter harm. So in this case...
Anybody, anywhere, patron kicks a member of his family when he gets home, uses the highway, everybody. So you'd include everybody, then you'd carve it out more on the basis of causation.
Causation, standard of care, remoteness, absolutely. Damages, absolutely. So yes, so there is a duty of care.
Isn't remoteness, isn't that proximity? Is that not the same idea?
It's part of the idea. Proximity is talking about the relationship, and so here we're saying the appellants and Mr. Donaldson were in a proximate relationship because they were their guests. So that's proximity. In terms of remoteness, we're looking at to see, was the harm too remote? Was it too far away? And if it is, then there are multiple elements of a negligence action, and 5 elements have to be met. And if all 5 elements are not met, then negligence will not be found, and the appellants will not be held liable. May I proceed?
Unfortunately, yes. We all say yes to you. Yes. It's not unfortunate for us, but for you. You had this look on your face.
So, having that said, the appellants ought to have reasonably known that Mr. Donaldson and other members of the community may be directly affected by their lack of due care. Therefore, there was foreseeable harm, and there was a foreseeable plaintiff, and the only remaining question is whether there are sufficient policy considerations that would negate this duty. Opposing counsel has submitted 2 policy considerations to negate this duty. 1, they said that this would open the door to, quote, trivial lawsuits, and 2, that this would create indeterminate liability. We refute this claim on 4 grounds. 1, policy concerns must be more than speculative. There has to be definitive potential for negative consequences. Opposing counsel has submitted no empirical evidence to substantiate this claim, and therefore, it is merely speculative. 2, we submit there is nothing trivial about the physical assault that can result as a result of people under the influence of alcohol. 3, the purpose of tort law is not only to provide compensation to victims, but to provide a deterrence to other potential tort feasors. Recognizing this legal duty would provide a powerful